Hello, everyone, and welcome. Thank you for joining us in this webinar session. My name is Alison. I work for Trinity College London as the Head of Business Development for the UK and Ireland for language and secure English language testing. I want to welcome you all here. Thank you for taking time out of your day to join us for this webinar, which is all about the immigration white paper. I recognize lots of names in the attendee list, so thank you for joining us, and I hope there will be some people here maybe who don't know too much about Trinity, but who would like to learn a bit more about what we do as well. I wanted to introduce our speaker today, who is Mohammed Hafaji. Hello, Mohammed, welcome. And
Thank you,
Mohammed
Alison.
is conducting today's session about the white paper. Mohammed is actually an ambassador for Trinity, so we're delighted to have him presenting today. He has a huge amount of experience, which his career began in 2009 across all aspects of immigration law, but he's had a particular focus on business immigration. And he joined Latitude Law as a solicitor in 2021, rising to a senior associate in 2023. He has a huge amount of experience in representing businesses across the UK in submitting their sponsored license applications and making sure that businesses comply with their license duties in accordance with Home Office requirements. He also regularly advises employers in relation to employee compliance, including the right to work checks. So I am delighted to pass over to Mohammed today. He's going to take you through the presentation, and I will join him at the end. Do feel free, if you have questions as we go along that you would really like answered, please use the Q&A box. The Q&A box you can find along your controls either at the top of your screen or the bottom of the screen, but in that way we won't lose any questions in the chat. We've got a nice group of people here, but if there's something that you'd really like answered, please do that, and I'll come on at the end to assist with Mohammed in just fielding some of those questions. So I'm going to pass over to you, Mohammed, and go from there. And I can see your screen. That's all good.
It's all good. Thank you very much for the introduction, Alison. I'm not sure if it's. I'm sorry. For a moment, I was just able to. It was quite echoey, but that seems to have settled down now, thankfully. So welcome everybody to today's webinar on the Understanding the Immigration White Paper. As Alison kindly introduced in terms of my situation, in terms of bio that was provided, I think Alison mentioned, due to a fault of my own, that I was a senior associate. I've actually been promoted now to partner at Latitude Law, which is quite recent. So, in terms of Latitude Law, just to give you a bit of a background, we're a leading legal 500 firm. As you can see from our credentials, we're also ranked as one of the best law firms in 2024 and hopefully soon to be in 2025 updated list as well. So in terms of the issue of what I'll be covering today, as I mentioned and as Alison has also explained, is in regards to the white paper, which the government has recently published. Now, the white paper, officially titled as Restoring Control over the Immigration System, was published on the 12th of May 2025 by the UK Home Office, or by the recent government. Now, according to the recent Prime Minister's speech in regards to the white paper, essentially it's all to, the purpose of the white paper is to reduce net migration, which seems to be at an all-time high. Now, net migration, according to the Prime Minister, has risen from 224,000 in 2019 to 906,000 in 2023, and every year it's been going higher. So the government's proposals now seek to turn the page by reducing migration across all categories, whether it's work, study, family, and settlement, and replacing what the government calls a one nation experiment in open borders, and to have it more controlled in terms of like a points-based system, which I'll go through. So one of the white paper primarily is to, a lot of the changes is in regard to the work-related routes and business immigration, as we call it, when it comes to a lot of the visa categories. Yes, there is mention, which I'm sure some of you may be familiar with, in regards to family and partner visas and certain requirements which are going to be updated for that in regards to settlement and English language criteria, which I will come to towards the end of the as part of my presentation. But to start off with, one of the major changes that the government have proposed is in regards to what is known as the RQF level, which is the type of level of experience and qualifications that you need for a particular role. So the changes after Brexit, skilled worker visas were more or less RQF level 6 initially. So that is degree level type jobs. Now, you don't necessarily have to have a degree to satisfy that criteria, but the jobs are at a level which you'd expect someone who's got a degree to be at those level of jobs. However, after Brexit, to accompany more jobs to be applicable for the skilled worker list, the government actually reduced that level to RQF level 3, which is A-level type jobs. And again, as I've explained, you don't necessarily need to have an A-level. It's just the level of jobs is equivalent to someone who may have an A-level or in that equivalent. So again, post-Brexit, that increased this skill list, which is known as appendix skill occupations, to various lower skill jobs, should I say, which were essentially initially on the skilled worker list. However, as a result of the proposals, the government now wish to increase that level again from level 3 back to level 6. Now, that's going to cause a huge problem to many sectors. Firstly, as you can see from the third bullet point, that's going to reduce eligible skill roles, which are currently on the appendix skill occupations for skilled worker visas, down by, it will deduct at least 180 occupation codes, which is a lot of codes which will no longer be applicable. And the jobs that will most likely be excluded from the skilled worker route include a wide range, for example, supervisory and technician level positions, as well as other sectors as well, whether it's to do with care, customer service, catering, warehouse, and also construction type jobs, usually, as skilled as they are in regards to when it comes to RQF levels, that will fall below level 6. So that will have a big impact on skilled worker visas. When it comes to increase of skill level thresholds, for example, again, if some of you are familiar with what the appendix skill occupations, which has a list of all jobs and salaries for the skilled worker visas, the higher the RQF level job tends to have a higher salary level. So for skilled worker visas, all baseline salaries or general rate is 38,700, or you have to pay the relevant rate for the role. So, for example, as a lawyer, as you say, the going rate for the role is 40,000. Instead of paying 38,700, which is a general rate, you have to pay the relevant going rate for the role. So a lot of the RQF level roles have a higher salary of 50, 60, 70,000 plus salaries. So it's a matter of time that when they update the RQF level 6 levels and reduce the or take away, should I say, the RQF level 3, 4, and 5s, whether the government will increase that general threshold of 38,700. There's no talk of it, but there's a possibility. And there's a good possibility that in regards to the going rate for the roles, that they could be increased as well. And the MAC, which is known as the Migration Advisory Committee, they usually advise the government in many aspects of immigration. And as part of salary thresholds, they're expected to undertake a review of salary levels, including discounts. Discounts, basically what that means is certain professions, for example, require PhD qualifications, or if it's a shortage occupation role, which I'll come to shortly, where there's a requirement for these sort of roles or workers to fulfill these roles, there's a reduced salary discounts. Now, so instead of being paid the full 100% going rate, you could pay 90% of the going rate, you could pay 80%, for example, if it's a STEM subject. However, whether that will be taken away moving forward and there'll just be a baseline general rate or going rate, only time will tell. And as I mentioned in the bullet point there, the Migration Advisory Committee will undertake a review of salary levels and propose that to the government, whether that should still remain the same or whether that should change. One of a big impacts of the proposed changes to the skilled worker list is a new reworded, should I say, known as a temporary shortage list. Now, the temporary shortage list will replace what is currently the immigration salary list. Now, immigration salary list, in simple terms, is when I've made reference to a shortage occupation list, and that's what it was called up until last year when it actually changed. So earlier this year when it changed to immigration salary list. Now, in terms of the shortage occupation list, there's certain jobs on there where there's a shortage of workers, or that could be the care sector, that could be construction, certain engineering jobs. And however, the government now wish to reduce that to, in terms of the list, to possibly reduce that list, which has probably got around 40 jobs right now, to maybe even lower. But at the same time, they want to make it more time controlled. So every now and then they will get certain government approved workforce bodies. That could be Skills England, the Department of Work and Pensions, or even the Migration Advisory Committee, who will play a central role in overseeing the TSL, which is known as a temporary shortage list, in regards to what jobs should actually be in there. So they could be in there for a year or two and then realize that, we can, or the UK can recruit the workforce from within the UK, and therefore there's no need for this temporary shortage list to be on that list, and they could reduce it or take that particular role away from the list. Now that could have an impact on those who are currently on the list or who are on the list at the time if it gets removed, but only time will tell in regards to what rules that the government will propose in regards to that. So again, in simple terms, the temporary shortage list will replace what is known now as the immigration salary list. And in regards to the temporary shortage list, just by the way, they could include roles which are below RQF level 6, because again, just using construction as an example, that could be equivalent to RQF level 3 or 4. But because there's a shortage of construction workers in the UK, there's a possibility that they will still remain on that list. Again, that will be has to be justified by the MAC, and also as part of the temporary shortage list, government approved workforce strategies have to be in place to show that why this particular role has to be on the shortage list. And it could have an impact on sponsoring employers, because the TSA represents a significant compliance challenge, where employers and also sectors have to show why there's a need for the particular role had to be on the shortage list. And sponsors will no longer be able to rely on straightforward eligibility requirements, which are under the current points-based system. Just to let you know, if you're not aware, this current immigration salary list has a lower salary threshold of 30,960 compared to a general rate of 38,700. So there's whether that will be deducted away, again, time will tell, and that can have an impact on in terms of sponsors, in terms of how much they have to pay relevant workers. In terms of fees, we're likely to be increased for businesses as well, unfortunately. So at the moment, apart from visa fees for skilled worker visas, when you assign a certificate of sponsorship to a sponsored employer, to a potential worker, each business has to pay what is known as a immigration skills charge fee, which is an added tax as part of the sponsorship, as those immigration lawyers like to call it. So when you assign a certificate of sponsorship, there's an initial certificate of sponsorship fee of £525, which was recently increased from £325, I believe, or in that region, 389 or something in that region. So that's £525 is the fixed rate for the certificate of sponsorship. But on top of that, they have to pay a ISC immigration skills charge fee, which is currently £364 for a small business, which is usually a business less than 50 employees. Or if you're a medium or a large sponsor, which is, let's just say, more than 50 employees, then you have to pay an additional £1,000 for each year of sponsorship. So it can accumulate quite high in terms of depending on the length of sponsorship that you wish to sponsor a worker for. Now that's going to go up by 32%. So just to give you an idea, from £364, it will increase to £480.48. And for large sponsors, the immigration skills charge will go up to £1,320 per year. So you either times that by 3 or times that by 5. And on top of that, you pay the £525 fee as well. And just to, as Alison's mentioned, the slides will be provided at the end, so that will be provided to you. One of the major changes in regards to the English language criteria in regards to the white paper proposals, and I'm sure if you're an English language provider, this will be very useful for you. At the moment, skilled worker visas requirements or requires English language to be at CEFR level B1 in all 4 components. So that's speaking, listening, reading, and writing, and not just speaking and listening as it is for partner visas. However, that is going to increase to B2, level B2. And students with a degree from a UK university can continue to meet that criteria by providing their BA level or above degree certificates. So that should remain the same. Or again, if you've got an overseas degree, you could rely on a UK ECTIS confirmation to confirm the equivalent level of English language and the fact that it was taught in English as well overseas. However, there's going to be changes to dependents. Now, as some of you may be aware, healthcare visas no longer allow dependents to come to the UK, which caused a shortage of now care workers applying for care workers if they can't bring, spouses, partners, children under the age of 18. That does restrict it stops these workers from coming to the UK. No one wants to be separated from their families, and that could be the case for TSL roles, so the shortage list, which I've mentioned, the temporary shortage list. The government may introduce a restriction that dependents will no longer be applicable to come to the UK to join their partners if a job is on that TSL list. At the same time, there's going to be a requirement for skilled worker dependents to meet at least a minimum level of CEFR level A1 for entry clearance. Now, as it stands, unless skilled worker visas, global talent visa dependents, or skilled worker dependents, do not need to meet a English language criteria, but that is something that could be introduced or will be introduced, in accordance with the proposals, where level A1 will be required for entry clearance. And then usually skilled worker visas are extended after 3 years, so there may be a requirement for dependents to apply for level A2 for the extension. And when it comes to settlement, it's very likely that it's going to increase from B1 to B2 as well. As part of the increase of trying to get domestic workforce to work in certain sectors, which when I gave that brief explanation in regards to the TSL sectors such as construction, care workers, they tend to usually, or care sectors tend to stand out in regards to shortage of British or settled workers already in the UK. The government have wished to introduce a labour market evidence group. Now, this is going to be a new group which is going to be created to gather data for the UK labour market, and that'll be comprised of Industrial Strategy Advisory Council, the DWP, Skills England, and again, the Migration Advisory Committee. So these groups will put their ideas forward based on extensive research and data, and it will be in regards to sectors which are identified as having high level of recruitment from overseas. And these sectors will have to provide a workforce strategy, setting out what needs to be done in terms of skills, training, and other work conditions, and how they're actually engaging with people in the UK before they actually try to recruit from overseas. There's very limited information at this moment in time in terms of the labour market evidence group, but in a nutshell, they will have to gather as much data as possible to put forward why these sectors require overseas workers and why they cannot recruit here in the UK. I keep mentioning one of the key changes, but there are many key changes, but one of a key one is in regards to adult social care. Over the years, there's been a shortage of adult social care workers here in the UK, and as a result, a couple of years ago, in terms of the health and care worker visa allowed care workers to be put onto that list for health and care worker visas. Now, due to abuse, in the system, unfortunately, maybe by some sponsors and some workers not being paid properly, there's various bad press in regards to care workers. That's actually going to be taken away from the health and care worker category possibly by the end of the year in terms of new applicants coming from overseas. Now, there was a change earlier this year where if you are currently in the UK and you're out of work as a care worker, you have to contact your regional care providers to try to get regional care providers, as in there's a body in terms of care assistance for each new region in the UK. And if you're a care worker who's out of work, you could approach these providers and they could try to help you try to get care work again. But at the same time, one of the major changes was if you're a care provider, before you look for anyone overseas, you have to try to contact these regional providers as well. So if you're in the north of England, there'll be a provider in the north. If you're in the south, there'll be a provider in the south, where you have to try to contact them first to see if they've got any workers who are in a pool who are out of work, those who may have lost sponsorships, in order for you to recruit them first before you could try to make an overseas application for migrant to come overseas as a care worker. However, that's going to be completely abolished. There's going to be no overseas care worker visas for care workers, possibly by the end of this year. However, those who are already in the UK as care workers, there are going to be transitional provisions in place up until 2028. Where they would possibly allow extensions or settlements, and then we'll just have to wait and see what the rules are for anyone who may not be able to make use of the transitional provisions after 2028. And in terms of the reason why they wish to do this is because the Home Office contends that persistent shortages in the adult social care sector is not due to lack of available labour, but rather due to poor pay conditions and career progression. So maybe that could try to change in regards to trying to get more of the settled workforce to apply for these sort of roles. And as a result, the government has pledged to shift responsibility for workforce reform away from the immigration system and try to get the domestic workers to try to apply for work in the care industry. So in a nutshell, again, adult social care visas will no longer, health and care worker visas will be available, but to work in the care sector as care workers or senior care workers will be taken away for entry clearance, possibly end of this year. And there is some good news in the white paper proposals, not many, but this is one of them. The government wished to try to target more highly skilled or talent to the UK. That could include those who work in digital technology such as artificial intelligence, global talent route, which includes the creative arts, research, digital technology, science. Try to make it a bit more simplified for these highly skilled personnel to try to come and benefit the UK in accordance with the government. There is a visa at this moment in time called an Innovator Founder Visa, which is a business-related visa, which is very difficult to achieve. It's an endorsement-based visa. And however, the government wished to conduct a full review in regards to trying to make it a bit more easier or more candidates to apply, but at the same time try to work closely with UK universities in terms of students who may have that entrepreneurial spirit or background, should I say, where they may be able to apply for the Innovator Founder Visa. So they'll work closely with universities. And there's a high potential individual visa, which if you're a applicant from a certain university, which is on a list of global universities which qualify for the high potential visa. Let's just use Harvard or Stanford in the US as examples. There's around 15, 20 universities on the list, and however, the government do wish to double that list to bring more high potential individuals to come to the UK. There may be a cap on how many may be able to come, but it's something that's going to double, so we may get more applicants for high potentials. A major change which as soon as the proposals came into force, myself, my colleagues, and I'm sure many other immigration lawyers up and down the country, got calls from existing clients asking, am I going to be affected from my current visa? Can I still apply for settlement, or known as indefinite leave to remain, or ILR, as mentioned on the slide, after 5 years, or will I have to now increase to 10 years? At this moment in time, there's nothing in concrete in terms of rules changes. Whether that's going to affect existing visa holders or whether it's going to be only for those who are applying for visas after the rules are changed to settlement period to 10 years. Now, just to make you all aware from previous experiences, every time rules change, there's always transitional provisions for those who are currently on visas before the rules changes. So though it's very likely that those who are currently in the UK, as whether you're here as a skilled worker or as on a partner visa, that yours will remain 5 years because you are here before the rules change. and anyone that comes after the rules change will probably have a qualifying period of 10 years for settlement. Again, that's my point of view. It's not guaranteed, but there's a good chance that transitional provisions will maintain. However, the government have confirmed that certain categories will still remain as 5 years. That could be dependents of British citizens, spouses, children, so that's family, parent, or partner type visas, as it is right now. Refugees have a 5-year route to settlement, so that will most likely be the same. And vulnerable migrants, those who have suffered unfortunate domestic abuse or trafficking, or even those who have lost partners, bereavements, bereaved partners could possibly apply for early settlement as it is right now. However, there is going to be a new settlement model in regards to what's mentioned in the white paper. Now, there's going to be ways where you could probably get accelerated or what is known as enhanced settlement. So instead of waiting 10 years, there could be a way, if you're here as a skilled worker after the rules change, where instead of waiting 10 years, there may be a possibility that you can apply for settlement after 5. However, there's additional criteria that has to be satisfied. That includes, for example, if you've worked in employment, so if your employment includes education, health, or defense, your exceptional talent, innovation in science, technology, or the arts, there's community engagement or volunteering work. That's something that may push people to do if they're on a 10-year route to settlement, to try to get them to settlement quicker. And then there may be a stronger English language proficiency and proactive engagement with civic institutions. So doing more for the community could potentially get you that accelerated settlement instead of waiting 10 years. And as it stands, I'm sure everybody knows the Life in the UK test can be a right pain to prepare for, and also a lot of the questions, aren't relevant to any of us. So the government have said in the white paper that they'll review the Life in the UK test. The current test is outdated, overly focused on obscure facts, and does not adequately assess civic understanding or integration. So that could change. There could be a new Life in the UK test, or there could be other ways instead of passing the Life in the UK test to get as part of the settlement criteria and also as part of accelerated settlement. I touched up on English language criteria when I was talking about dependents for skilled workers, but again, going as an overall when it comes to worker, students, or family route sponsors, there is going to be a basic English language A1 requirement for dependents, as I mentioned, for skilled workers, for example, where it's not required at this moment in time. As most of you may be aware, there's already a A1 requirement for partners' visas over the age of 18, where there's A-level English language criteria. Extension will probably remain at A2 as it is for partners, but also that will now be applicable for dependents of skilled workers. And settlement at this point is level B1, but there's a good chance that it's going to increase to B2 when it comes to settlement for partners as well. Now, as it stands, partner criteria is only speaking and listening, whereas skilled workers is all 4 components, as I mentioned earlier: speaking, listening, reading, and writing. Whether that will change for partners as well, that it'll have to be all four components for B2 level. Again, we'll have to wait for the full confirmation for that. Hopefully that will remain at just speaking and listening, but understandably for skilled worker work, reading and writing is important as well. So that will probably remain the case, apart from the fact that it's going to increase to B2 level. In terms of the financial requirements for partners as it stands, when the rules change in April 2024, from 18,600 it risen to 29,000, which is a pretty high substantial increase. And the government have proposed, even when the rules happen, that eventually they'll want to increase it to a level in stages to 38,700 by early 2026. And as I mentioned, 38,700 is the same general rate as skilled worker visas. Now, to an average person, 29,000 is a high salary, let alone 38,700 is ridiculous. But at the same time, in some good news, the MAC have conducted a recent report just earlier this month in June 2025, where they argued against the increase, saying that the proposed salary figure for skilled worker visas of 38,700 shouldn't apply to partner financial criteria. However, if there is a average threshold which is reasonable for partner visas, that would be in the region of around 23 to 25,000, which is achievable compared to the 18,600 back in 2011 when the rules came out or changed to 18,600 at the time. Minimum wage now can possibly be achievable to that 23,000, 25,000 £30,000 based on full-time employment. So it's unlikely that it's going to increase based on the Max report. Another major change is in regards to the graduate visas. If any of your students at this moment in time or on graduate visas, as you may be aware, graduate visas at this moment in time allows 24 months to do post-study work, and it's an unsponsored route, a great route to build experience in the UK to eventually go on to a skilled worker visa. It's 24 months or 36 months if you're a PhD student. You could get 36 months under the graduate route, or a lot of you may refer to it as a post-study work route. However, that's going to be reduced to 18 months. The government have done some research, and it appears that a lot, between 30 and 70% of graduate visa holders are not working at graduate level jobs. That's what they want to encourage. So that's something that was proposed, that graduate visa may change, that it has to be graduate level jobs for you to be on that visa. I don't think that they've mentioned that in the white paper proposal. It's something that they possibly the government wish to propose or wish to introduce maybe in the future, but the main changes is going to reduce from 24 months to 18 months. There's going to be some key changes to short-term student visa holders and also to student sponsors. There's going to be strict compliance, especially for student sponsors, to ensure that students that are coming to the UK to study are actually enrolling on their course and also completing their course. Just before I come to that 48% short-term student, I'll just touch upon the requirements for, which is in the last few bullet points about the 95 and 90%. If you're a student sponsor, once the new rules come into place, there has to be a 95% enrollment rate, ensuring students commence their course as intended. And because some may come to the UK, because what the government have stated is a lot come to the UK and then end up claiming asylum. So in order for student sponsors to ensure that the students actually coming to the UK, there is going to be this enrollment rate of 95%, of which 90% must have completed their course. If they fall below these statistics after maybe annual reviews, they could be put on, there's a possibility that the licenses could be suspended or revoked. They may be put on some sort of action plan. They're going to have like a traffic light criteria. Red, amber, green. Green's everything's fine. Amber, there may be some action plans in place for student sponsors, and red means they're in trouble. So that's something to be aware of if you're a student sponsor. And also, if you're a sponsor that uses recruitment agents overseas, you need to sign up to what is known as Agent Quality Framework, where the government possibly will work with these external quality framework bodies to ensure that the person that you're or his student who is coming to the UK to study has the relevant qualifications or meets the criteria in order to do so. And touching up on short-term students, short-term student visas is essentially like a visit visa where you could come to the UK for up to sorry, excuse me. Where short-term students can come to the UK for up to 11 months to study English language. There seems to be a very high refusal rate, as you can see, as I put in the slide, and in accordance with the white paper proposal research, which they've mentioned on there. There was a 48% refusal rate in 2024. That could be because the entry clearance officers do not believe that the potential applicant is going to be a genuine student to come to the UK, may wish to come and have other intentions. It's very similar to visit visas. There's always a high refusal rate from certain countries because the entry clearance officers or the Home Office many times do not believe them to be genuine visitors. Lastly, will the current proposals affect current visa holders? As I mentioned in one of my previous slides, transitional arrangements likely to be in place for those who are currently on visas, like partner visas. They remain on 5 years, and English language may still require B1 for those already there. In terms of skilled worker visas, those who are currently on skilled worker visas before the rules change, likely to still be able to apply for settlement after 5 years, hopefully. But again, these are just my points of view. Things may drastically change where they just update everything out of the blue. But it's again, like I said, in the past, every time rules have changed, transitional arrangements have always been in place for those who are on current visas before rules change. I hope that was all clear. Just finally, before any questions, just to let you know, if you do require our services or have any further questions after this, I've put my email address there. It's mhafiji@latitudelaw.com. As I said, I'm a partner at Latitude Law, so our website's there, our contact number, and you can also use the QR code that should take you directly to our website. So hopefully that was all clear and very helpful, and if that's good, then hopefully some questions for me to answer.
That's great, Mohammed. Thank you so much. There are a couple of questions in the Q&A box, and Mohammed, could I just ask you just to stop sharing for just a moment, if that's okay?
I'm sorry, one second.
That's okay.
Yeah.
Great.
There you go.
Okay. And some of these I think are tricky questions because they're probably going to be a bit speculative. But the first one is from Seema, and there was a couple of questions around the Life in the UK exam. Obviously, the content being very outdated, but Seema is wondering if there might be a move to possibly combine the Life in the UK content with the Secure English Language Test. Any thoughts on that? I guess that is very speculative.
As you mentioned, Alison, a lot of these answers, unfortunately, will be speculative answers. In terms of the new Life in the UK test, whether it's going to be combined with SELT test, I don't think, personally, I don't think it will, because SELT test will just be in regards to English language criteria, whether it's speaking, listening, or reading and writing, inclusive as well. And Life in the UK test, they'll probably just have a more different approach in regards to how somebody can be a bit more engaged with the UK. That could be, as I mentioned, about the civic associations. In terms of the testing, whether they could make questions which are more applicable to recent days instead of history about the 1500s, which it is at this moment in time. But in terms of combining it with the SELT test, I doubt it, because they seem to be two complete different aspects. But again, you never know.
Yeah, okay. I think that's probably answered Shaista's question too, really, because, well, when might that take place? Again, very speculative, but I think it's clear that there is a feeling that test does need to change and it needs to be brought more up to date. So, but no real idea yet when that might change. Okay. Wahid is asking, and I don't really know the answer to this, but I don't know if you do, Mohammed, but some sort of way to report non-enrollment students who are coming in on a short-term study route.
Yeah, in regards to the short-term study route, I believe at this moment in time, I'm not 100% sure, but I don't think there's a requirement to notify the Home Office at this moment in time. There may be a requirement for when the new proposals come into force. But just to give you an example, if you are a sponsoring organization of students, like universities, for example, which tend to be, or even other educational institutions, then yes, there is a requirement to report for any sponsored students that do not take their course or withdraw from their course. There is that requirement, so it probably could be good practice to report. But again, I'm not 100% sure for student sponsors in terms of for organizations that have short-term students that wish to come for the 6 to 11 months. But I don't think it's in there at this moment in time.
Okay. Yes, and actually Wahid's questions are all sort of related there. I think it's about a framework and what the process is going to be going forward, isn't it?
Yeah, we'll have to wait for that. At the moment, it's just a few paragraphs or one paragraph in regards to the agent quality framework. I've got I don't have any more information, unfortunately, at this moment in time. But when the new proposals do come into force, that's when we'll be able to give some more information. Just for everybody else's reference, just before any rules come into force, the government publish what is known as statement of changes. So the statement of changes are basically will have the new rules and they'll have a date of when they're going to come into force by. Now, usually by law, they have to allow at least 21 days from the date of statement of changes to the first particular change. So just to give you an example, English criteria from B1 to B2, they'll say anyone applying after this date, it'll come onto force on this day. So there is that grace period that if you need to get a quick application in for entry clearance based on a A1 level instead of B1 level, they do give you that period to do so. Yeah. So it won't just be, it'll come out today and the rules change today or tomorrow. They give you that grace period.
Okay. And Shanaz's question, I think, is related to Trinity SELT approved service provider. So I'm going to come back to that in a moment.
Yeah.
And let's just see, Jenny, I'm not clear whether our current refugee students will need B2 or whether Jesse 5 will
Yeah.
be appropriate. Um, this is a big question, whether it's going to be B2 2
Yeah.
skills or B2 4 skills, even for us. And I
Yeah.
think, you know, for us, it's more about enabling the training providers that are part of the Trinity network in terms of, you know, training for teachers and supporting in that way, where students may need to study longer because they're not yet at that
Yeah.
level. So that is something that's definitely on our radar, as you know, as Trinity and being an awarding body. And of course, we also do a huge amount of teacher training with TESOL qualifications. So we will kind of rally all of that experience to support people that are working in our network to help students that have that higher language requirement. But Jenny, we don't know yet whether it will be 2 skills or 4 skills, I think is the
Yeah.
simple answer there.
Yeah. I mean, if I could just mention, in regards to refugees, those who are in the UK as refugee status holders, when it comes to their indefinite leave to remain, there's no English language requirement. However, that may change again with the proposals, but I think it probably will remain the case, where hopefully it doesn't. But it just, again, we'll just have to wait and see.
Yeah. Okay. And Jenny's also asked about the PowerPoint. I think, yes, what we'll do is we have recorded this session. So everybody that has registered, I think we'll send the recording plus the PowerPoint, if that's okay, Mohammed. And
Yes,
yeah,
absolutely.
I
That's
think
perfectly
Jenny was
fine.
trying to read your email address. I don't know if you want to
Yeah.
pop it in the chat for
Yeah, I'll
anybody.
do that.
It's quite
Yeah,
hard.
I'll pop in the chat right now.
And whilst you're doing
Uh,
that, I'm just going to share my screen very briefly. Um, and this is really just because I think we've got some people who have joined the session who maybe aren't in our network at Trinity. So we have, I recognize lots of names of people who are already approved service providers and kind of work with us in that capacity, and as exam centers too. But if you're kind of new to Trinity and really kind of want to understand how we work with all sorts of training colleges, charities, private language schools, we work across sector really, where organizations can become a SELT approved service provider. And that really is about supporting people on their learning journey and the assistance that they need when it comes to taking their secure English language test. So as part of being in that network, it's an application process. It's quite straightforward, it's free, but we do a huge amount of training through the year to understand secure English language testing and how best to prepare students that really need to improve their level of English. We have an account support team here at Trinity that works with all of our service providers. You get some added benefits around being able to reschedule or cancel candidates without any fees. So that's quite handy if you're trying to help somebody. And we also have access to a sort of full marketing support hub just to help with promotion. And then you're able to use the Trinity logo on your website as well. Certainly for citizenship and extensions, Trinity we are one of the market leaders, quite far and away, certainly for citizenship. So Trinity is a brand that's kind of out there in communities. There are people who talk word of mouth and so on. So we do get recommended. But we'd love to hear from you if you've not applied to be a provider with us. We'd love to hear from you. Okay, I think that brings us to the end. I'm just going to pop the Trinity details on there as well. So if you have general inquiries about secure English language testing, you can contact deborah.morgan@trinitycollege.com, or just general queries about language and TESOL, you can reach us at uklanguage@trinitycollege.com, and somebody on the Trinity team will answer your question. Again, we will be sharing the recording, and we'll also try to put the slides out there for people to refer back with huge amount of information, but I found it a lot clearer after that, Mohammed. It's like distilled down into
yeah.
the key points. So I want to thank you for doing this presentation today, and I hope everybody who joined found it helpful, just a little bit of clarity on a very complicated process. So thank you.
Thank you very much. It was a pleasure presenting, and
Great.
Hopefully that has made it very clear. Well, made it quite clear for everyone.
Much clearer, definitely.
Thank you.
Right. Okay. Thank you to all of you for taking time out of your day and joining us. And as I said, we will be in touch with the recording and the slides. So thank you for joining us. Okay. Bye-bye.
Thank you.